In a relief for Patanjali Ayurved, the Supreme Court has refused to interfere with the Madras High Court order which allowed the company to continue using the trademark Coronil. The Apex Court observed that it will be terrible to stop use of the word Coronil since there's some pesticide already being marketed in its name. Court has asked the petitioner Arudra Engineers to argue the case before a division bench of the Madras High Court. The petitioner has claimed that he owns the trademark Coronil since 1993. A division bench of the Madras High Court had stayed a single judge bench order which had imposed a Rs 10 lakh penalty and restrained Patanjali Ayurved from using the trademark Coronil. Petitioner Arudra Engineers, a manufacturer of sanitizers and chemicals, has claimed that it owns the trademark Coronil since the year 1993. A bench led by CJI S.A. Bobre, also comprising of Justice A.S. Bopanna and Justice V. Ramasubramaniam, allowed the petitioner to argue the case before the Madras High Court, where the case is listed for further consideration on the 3rd of September. The firm has claimed that Coronil is a trademark owned by it since 1993. The company's registered trademark, called Coronil 92B, is an acid inhibitor product to clean heavy machinery and chemical preparations for industrial use. The petitioner contested an order passed by the division bench of the Madras High Court, which had issued an interim stay on the single bench order restraining Patanjali Ayurved and the Divya Yog Mandir Trust from using the word Coronil in relation to its immunity boosting products. Ayush Ministry had only given permission to sell this particular formulation as an immunity booster and not as a cure for COVID-19. In the High Court, a bench of Justice R. Subaya and Justice C. Sarvanan passed the order on an appeal moved by Patanjali and the Divya Yog Mandir Trust. On August 6, a single bench of Justice C. V. Karthikeyan passed an absolute injunction order restraining Patanjali from using the trademark Coronil after it observed that Patanjali was exploiting public fear by projecting that they could cure COVID-19 when actually their Coronil tablet was not a cure but rather an immunity booster for cold, cough and fever. They were directed to pay costs of Rs 10 lakh to the Adyar Cancer Institute and the Government Yoga and Naturopathy Hospital in Chennai. Thereafter, they moved a division bench of the Madras High Court and had secured a relief, and the relief was sustained by the top court today. It remains to be seen whether the top court's order from today will have a bearing on the High Court observations and any further consideration when the case next comes up for hearing before a division bench of the Madras High Court.